I know there can be a million reasons why you haven't gotten around to creating your estate plan yet. However, if you finally realize the importance, let's look at 5 tips for you to create your first estate plan. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City, and today we'll walk you through 5 quick tips of things you want to consider as you create that first estate plan. Now, if you've watched some of the other videos from my channel, we've looked at things like celebrity estate plans and some of the little intricate things that happen in your will or your trust or some of the ancillary documents. And you may be wondering, wait a second, I'm not even sure what an estate plan is. I know that I need one. I've seen it in podcasts and read about it in blogs. I've heard people talking about it. My parents probably had one. But what is an estate plan? Well, when you hear people talk about an estate plan, it's generally the set of documents that we're going to put together that deals with what happens if you become sick or what happens to your assets after you die. When we're considering things that happen when you become sick, those documents are called powers of attorney. We want to look at a power of attorney in the healthcare field, and we want to look at a power of attorney for your finances. And what these powers of attorney will allow you to do is have somebody else be able to make those decisions for you if you become sick and you're unable to speak for yourself. Obviously, the last few years have taught us the importance of having powers of attorney in place, because if you caught COVID or something else that left you really unable to manage your affairs, those powers of attorney come in handy. And the second part of the equation is for documents that happen after you're gone, and that's going to be your will. And your will is going to say what happens to your things after you're gone, and if you have children, we'll set up a process for who will be the guardian and who will be the trustee for your children. Now, in between these two lies what's called a trust. So a trust is something we can set up while you're living, but we can also transfer assets to the trust that can then be managed after you're gone. So let's look at our 5 tips for today. Tip number 1, a bequest to your spouse. So if you're married and you're going to create an estate plan for the first time, don't leave your wife or husband out of it, or don't leave your spouse out of it. So in many states, if you try to cut your spouse out, they actually have what's called an elective share, which is a law in that state that says if a husband cuts his wife out of the will, the wife can still elect for a portion of the estate no matter what. So there may be reasons why you would try to cut your spouse out of your will, but for most people, you're married, you love your spouse, there's no reason to cut them out. So the first place we start when we're creating our estate plan is a bequest, or what are we going to leave to our spouse? Number 2 in the tips, what are we going to leave for our children? So many people's estate plan leaves everything to their spouse, figuring that their spouse will then take care of the children, and when that spouse dies, then the children will inherit everything from that spouse. But when you're creating your estate plan, you also have to think about that situation where, what if your spouse dies first? What if they die 5 days before you? What are we going to leave behind for our children? Now, if you don't have children, and some of my clients who are younger, they aren't even married yet, and they say, well, I don't have children, what should I do with this? You can look at folks like your nieces, your nephews, your cousins. If you have younger members of your family who could really benefit from an inheritance from you, you can look at them. And if that's the case, make sure you're leaving them a bequest or leaving them some kind of gift under your will. Number 3, who's going to be your personal representative or your executor? So these terms pretty much are the same person. It just depends upon which state you're in. Some states call them executors, some call them administrators, some call them personal representatives. Whatever your state calls it, the person's role is to take your will after you're gone, look at what it says, and divide up your assets, divide up your estate to whoever you've left it to. If you have children under 18, then we have a guardian appointed, and the personal representative will help the children get over to the guardian, help them get set up. If we have money that needs to go to a trustee, that personal representative or executor is there to make sure the money is transferred to them, usually with the help of a court if it's needed. So you want to make sure you're looking at the variety of options for who's the best person for this. If you're married, you're normally going to pick your spouse as your personal representative or your executor. But we always encourage you to pick at least 1 or 2 backup people, because what if you and your spouse are in the car at the same time and you're in a car accident and you're both gone? We need somebody else to be the personal representative. And if you both had each other in your wills, those second and third people can come into play. We want somebody who's responsible and somebody who's able to work with a lot of administrative tasks. So when you're working with a probate court, when you're working to distribute assets under a will, there's going to be a lot of calls to banks and other financial institutions. There may be dealings with the court. So whatever that system's going to look like for you, you want to make sure you have somebody responsible, but someone who can also handle it. There's a lot of people out there who can't handle all that paperwork. They just get too overwhelmed dealing with that much administrative overhead, and they've got other things going on in their life. So think about who that person is and make sure you're choosing the right person for that role. Tip number 4 is look at whether you want a will or a living trust. So it's the most common question that clients will have when they come to my office. If you've watched videos, you've read blogs, you've heard podcasts, do I want a will? Do I want a trust? If you listen to most podcasts, if you read a lot of blogs, almost everybody needs a trust if you believe them. And the simple answer is most people can benefit from a trust, although not everybody needs it. It's really going to depend upon what your state looks like when it comes to the probate court. So in some states where I practice, the probate court is still a total wreck after the pandemic. They're way behind on filings, things take forever, and even in the best of times you don't want to deal with them. When you're in a state like that, we want to look at something like a trust, which will take assets out of your name, and you can do this while you're living, and put them into a trust to be managed by a trustee. Now, if it's your trust, you can be that trustee that starts. You'll have a successor trustee down the road in case something happens to you, but you can move assets into the trust and manage them while you're still alive. If you're in other states where the probate process is streamlined, we have things like informal probate here in Minnesota, then I don't always recommend the trust for my clients because depending upon what they have for assets and what their goals are for their estate plan, the trust may not necessarily save them a lot of time or energy for their estate down the road. Their family may be able to handle a streamlined probate process versus trying to administer a trust after they're gone. So before you just go to some website and get convinced that you have to have a trust, make sure you talk to a professional. And that's tip number 5. Talk to your attorney, talk to your professional financial advisor, talk to your accountant, work with the professionals. We all work together. I have lots of phone calls with accountants and financial advisors where we talk about our clients, their financial situation, and what the best next option for them is. We talk about things like, do they need a will? Do they need a trust? What kinds of powers of attorney do they need? What does their asset mix look like? And what's the best way to pass on assets to our children? Maybe we have grandchildren, in which case we're really motivated to use a trust to leave money for them, or other folks are just going to use a 529 account to help pay for educational expenses. No matter what we're looking at, those professionals can work with you to really craft a plan and create where you want your assets to go in the most streamlined way possible. And remember, the government's out there and they're happy to take taxes where they can. So work with those professionals to see if we can minimize or eliminate any possible tax burden. So these are 5 quick tips if you're creating your first estate plan. And obviously there's a lot more that goes into creating an estate plan than what I can tell you about in a few minutes in the video. So if you have more questions and you'd like to set up a legal strategy session, go to my website, 𝙃𝙀𝙊𝙒.com. There's a red legal strategy session button on the front page. If you click it, you're taken to my personal calendar. We'll set up a 15 or 20-minute phone call to talk about where you are in the process. We can go through these tips. We can see what are you thinking and the best way to design your estate plan. I hope you enjoyed this video. If you liked it, you can hit the like button. You can subscribe to the channel for more videos. We have estate planning and business law. We have the Friday 5 with some questions each week. And I appreciate you watching my videos, and I hope to see you in the next one.